Good morning, Miss Bob.
Good morning, Your Honor. How are you this morning?
Good. How are you?
Good. I'm doing fine.
I think we are ready to take up the conservatorships that you have, and one of them, the first one on the docket is In re Betty Jean Williams. And I think
Okay.
I signed the order appointing a temporary conservator.
You didn't. I believe that is Claire Dunkley, Your Honor. I think she is also supposed to be on Zoom, as well as Leslie Wright being the attorney ad litem. They may be in the waiting room.
I'm admitting everyone into
Okay.
several people who will.
Perfect.
All right, Miss Leslie Wright, I'm going to ask her to unmute and start her video.
Can you hear me, Your Honor?
I can hear you, yes.
I'm having technical difficulties on my internet this morning.
Well, I can relate to that. So.
I apologize. I'm not sure what's going on here.
Was there anyone besides Ms. Wright that we needed to have in this hearing?
I believe Claire Dunkley, who is on, she is the appointed emergency conservator. There she is.
We'll ask her to. All right, she just came in. All right.
Okay. Perfect. All right, Your Honor. So this is the emergency conservatorship for Betty Williams. This is the more egregious of the two that we have filed. She is a resident at NHC Dixon, and she's actually a longtime resident of Dixon County, Tennessee, and she's been admitted. She has Alzheimer's, adjustment disorder, malnutrition, and just kind of failure to thrive. She's been there for quite a while, and upon her admittance, she had a power of attorney, which is the granddaughter, Tanya Haplin. She has since kind of disappeared, so the facility's not been able to reach her. The bill's not being paid. She has medical issues that need to be attended to, and they can't reach her. So they decided to do a wellness check on their own, and when they did that, it showed that the house has been abandoned. There's dogs that are in the house. One had passed away from malnutrition. The house has been absolutely trashed. And upon the appointment of Ms. Dunkley as the emergency conservatorship, we've been able to locate, at least Ms. Halpin has taken at least $300,000 from Mrs. Williams in the last 6 months. So we have been able to secure that bank account since we filed this immediate emergency petition. So we're just asking the court just to let us finish this out for the 60-day process to try to figure out what's going on. She needs a decision maker. Ms. Dunkley is an appropriate party to serve. We have a physician's report from Dr. Saw that has been filed with the original petition. We're asking the court to admit that into evidence. And I do not think that there's any opposition or defense to this appointment.
I have reviewed the physician's report. We'll have it marked as Exhibit 1, and we'll keep it under seal. Ms. Wright, I know you're not able to come on camera, but can you hear everything okay?
Yes, I can, Your Honor, and that's all correct, and it's very much appropriate for there to be an emergency fiduciary in place.
As far as Ms. Dunkley, let's go ahead and ask Ms. Dunkley if you'll unmute your device. Let me go ahead and place you under oath. I know you're an attorney, but we're going to go ahead and ask you to be placed under oath, so if you'll let me place you under oath. You raise your right hand. Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, nothing but the truth, the whole truth, so help you God?
Yes, Your Honor.
All right. Ms. Bobbitt, why don't you go ahead and, for the record, put on whatever proof through Ms. Dunkley about the facts that you've recited so that we have a record that's made of evidence.
Sure, Your Honor. First, I can ask to Ms. Dunkley, are you, obviously you're statutory qualified, you've not been convicted of any felonies or misdemeanors, correct?
That's correct.
You've not filed bankruptcy, correct?
That's correct.
Okay. And have you had a chance to review the petition that NHC Dixon filed with regard to Ms. Williams? Have you been able to meet with Ms. Williams at your appointment, and what was that meeting like?
I have met with her. She seems to generally know what's going on, but not in its entirety. And she is very frail. And so it was clear from my meeting that she definitely needs help.
Okay. And also, have you had a chance to look at the bank records that you were able to obtain from Pinnacle Bank?
Yes, Pinnacle has been incredibly helpful and very proactive with securing her bank account.
Okay. And can you just tell the court a little bit about what you saw in those bank account records and who the bank said withdrew the money.
Of note, most recently, since the power of attorney was revoked, Ms. Halpin had taken out 2 more withdrawals within the last few weeks, one of which was to pay, I believe, a medical bill that had her name in the memo line on this statement, and the other one was for a car payment that Miss Williams did not purchase that vehicle, to my knowledge. So the bank has been proactive with disputing that transaction and working on getting her money back, but we have eyes on the account to prevent that from happening again.
Okay. And could you tell that there have been numerous withdrawals over the last 6 months?
Yes.
Okay. And can you give the court a little estimation about the total value of those withdrawals?
About $300,000.
And who was the source of those withdrawals?
Ms. Halpin.
Okay. And did it look like any of those expenditures, the $300,000, was any of that related to Miss Williams or her care?
No.
I have no further questions, Your Honor.
Ms. Wright, do you have any questions? She may have left our hearing.
Nope, I'm here. I'm still here, just not able to work any of my devices this morning. I have no questions, Your Honor.
All right. I find that there is a justifiable need for the extension and making this a permanent conservatorship. And Ms. Dunkley, are you willing to continue to serve in that capacity?
Yes, Your Honor.
All right. Secondly, there are a few things that are more reprehensible than someone who takes advantage of a person that is disabled and elderly and takes things that don't belong to them. I've had some of that in my own family, and as a result of that, I will order that Ms. Dunkley or Ms. Bobbitt, I want you to refer this matter to the District Attorney General's office for the 23rd Judicial District, because in my estimation, Ms. Halpin is guilty of felony theft. And I think that there's also an abuse of an elderly statute that she may be in violation of as well. And I think it's very appropriate for the matter to be referred to the District Attorney General's office for their investigation and determination whether charges should be brought against Ms. Halpin. It's probably the only way that there's any chance of recovering any of that money for Ms. Williams. So, all right.
We will do that. Thank you, Your Honor.
Thank you. Ms. Bobbitt, you have the next case as well. So.
I do. This is the Pamela Duzak matter. This is also an NHC Dixon case. They brought this because there's no medical decision maker. She is in much need of medical attention, and she does have a brother. There's no spouse. There's no children. The brother has made it clear to the facility that he no longer wishes to be responsible for her nor any decision-making authority. So the courts the facility is asking the court to appoint an emergency conservator to address these immediate medical needs and then also to further assist with the TennCare application that's going to be due for her.
All right. And our phantom attorney, Ms. Wright, is not able to be with us in person, but she's on here online.
I am, Your Honor.
All right. And you are willing to serve as the ex parte, I'm sorry, you're willing to serve as the conservator. I think you were appointed ex parte. Is that correct?
Yes, Your Honor. I'm more than willing to serve. And like Ms. Bobbitt said, the biggest thing is there will be some healthcare decisions made, but it's a matter of getting her approved for TennCare, and I'm already working on that process.
All right. Do we need to put on any proof regarding that? I don't know that there's anyone that can really testify about it because of the sworn petition sets out the basis along with the attorney's report. I'm sorry, the physician's report, and that physician's report was filed with the court May the 28th of 2026. I'm going to mark that as an exhibit to this hearing so that we have a record.
Sure, and I believe Ms. Dunkley had a chance to meet with Mrs. Duzak, so I don't believe there's any defense or opposition to this one either.
Ms. Wright, were you able to meet with her and anything you can share with the court?
Yes, Your Honor. I don't believe that she's really able to understand or be able to put up a defense. I'm not sure that she really has one to begin with.
All right. That will be the judgment of the court.
We'll thank you, Your Honor.
Ms. Wright as the permanent conservator.
And Your Honor, just a quick question. Do you want to go ahead and preset this for the final hearing, both of these last two cases, or do we need to just set that closer to the 60-day window?
How far down the road do you want to have it?
I think that we should do this before maybe mid-July. I think that would be within the 60-day window.
Well, I will be in Cheatham County in July.
Okay.
We could, the only thing we have is July 30th with Judge Lockhart Mash. Any reason that she couldn't hear this? I mean, this is just basically to make the permanent disposition, correct?
Correct.
Right. Well, let's set both of these cases that we've had for a permanent disposition hearing in front of Judge Lockhart Mash on July 30th.
Okay. Thank you, Your Honor.
Thank you.
$300,000 gone. And the judge was furious. What started as a routine hearing turned into a shocking elder abuse case. A missing granddaughter, a neglected home, and hundreds of thousands of dollars allegedly drained from an elderly woman's bank account. Then the judge made a move nobody saw coming. Was this greed, betrayal, or something even worse? Watch the full courtroom drama now on the channel. Like, comment, and subscribe the Legal Lens for more real court cases.
Lauren Olivia McComb. Come up, please. I'm going to ask you to raise your right hand and let the clerk place you under oath. Thank you. You are Lauren Olivia McComb.
Yes.
Ms.
sir.
McComb, you have filed a petition asking to change your name, and I'm required by statute to ensure that you're not doing it for any illegal or inappropriate purpose. Are you asking to change your name to avoid criminal prosecution?
No, Your Honor.
Are you asking to change your name to avoid your just debts or creditors?
No, Your Honor.
And you've set forth the reason is you just want to go back to your maiden name and change your maiden name to your middle name. Is that?
Yes, sir.
You're wanting to go from Lauren Olivia McComb to Olivia McComb Brown.
Yes, sir.
Is that it? All right. Then you have an order prepared?
I do.
Thank you. I'm going to ask you to sign off on it as well. And I'm putting a line right below where I will sign. I'm going to ask you to sign your new name on that order, okay? All right, Ms. Brown, I have changed your name and signed the order, so you may get a copy of that from the clerk's office a little later in the morning for all your purposes, but you'll have to wait till it's transmitted to the clerk, okay?
Thank you so much.
Thank you.
Got an agreement on that.
All right, we'll show an agreed order. Good morning.
That's my motion to sell property and approve contracts. Your Honor, Miss Susan Petty is under conservatorship that started back in 2022. We've sold various other pieces of property that Miss Petty had owned in order to put that money into either her Charles Schwab account to let it draw interest, be used for her benefit. Your Honor, most recently, Your Honor, Mr. Petty, who is Miss Susan Petty's son and a co-conservator, Miss Margie Martin, who's standing here with me, received an offer to buy the condominium that was owned by Miss Susan Petty. Your Honor, I've attached the contract to the motion, and you can see the price that was offered for that condominium. Both Ms. Martin and Mr. Petty believe that that's fair, just, and equitable, and we would ask the court to approve that contract and give them the authority to sell that condominium.
All right, if Ms. Martin and Mr. Petty will raise your right hand, let's go ahead and place you under oath.
Or not start with you, state your name for the court.
Margie Martin.
And you received an offer to sell the condominium, is that correct? And who was that offer from?
Neil Trice.
Okay. And do you believe the contract that has been offered and the price offered in that contract is fair, just, and equitable?
We had some very good comparable sales, recent comparable sales that supported that price. And
You're asking the court to approve the two of you to be able to close that contract and sell this piece of property?
yes,
And the money for that will be put into either the Charles Schwab account to draw, account, or her checking account to be used for
Correct.
Susan Petty's benefit. State your name for the court.
Steve Petty.
Okay, you're the son of Ms. Petty, is that correct?
That's correct.
And you're a co-conservator right along with Ms. Petty, is that correct?
That's correct.
Okay, and you heard the questions I asked, you received the contract. It's fair, just.
Yes.
And, of course, you want to be able to sell this due to the fact that the increase in maintenance, insurance and things like that are increasing all the time, and
It's costing her about $4,000 a year just to own it.
with the maintenance coming up, it's gonna, eventually, it's eating down what could be used for her benefit. Is that correct?
Correct.
Your Honor, if you had any questions?
No, I think that satisfies the requirement that it's shown to be a fair and equitable price for the property and that it's in her best interest to sell it, so we'll approve the contract.
Your Honor, I believe that our office has already provided a order. It should be in the file. It was received, I think, 5/22.
There was an order that was submitted to approve the contract back in May. Is that?
5/22, yes, Your Honor.
All right, thank you. It has been signed.
Thank you,
All
Your
right,
Honor.
thank you.
Good morning, Your Honor. This is a motion to approve an auction contract resulting from a partition sale of some property located on Nottingham Drive in Dixon. Mr. Trice conducted that auction. His affidavit is exhibited to the motion to approve. They got an astoundingly good price for it, considering the condition of the house. And there were literally rooms in that house that you would not feel safe walking into. The court may recall some of the agonies of getting the defendants and the unknown druggies out of the place. That was finally done. A very successful auction, and we're asking the court to approve consummation of the contract according to its terms.
I've reviewed this, and it appears to me that that is, in fact, a very good price for that particular piece of property. So unless there's some objection voiced, I will approve the sale.
Thank you, Your Honor.
Good morning.
Your Honor, this is our motion to alter or amend. We had filed an affidavit of heirship in this case. You relied on that in your previous ruling. Something had come up that morning. I went back and investigated and realized we did in fact leave someone out of the affidavit of heirship. We have amended that and filed a new amended affidavit of heirship. So we have filed this motion to alter and amend to include Mr. Drayson Beasley. In our motion paragraph 5, subsection 5, 6, and 7, it's getting, in essence, redistributed there between Lachelle Hunt, Tawana Turner, and Drayson Beasley in the thirds instead of halves. And then this morning, Your Honor, I've collected some W-9s in paragraph 5.3, Vernon Holt. His first name is actually Arliss Holt, so it's Arliss Vernon Holt, but I will correct that in the order as well with Your Honor's permission.
All right, I think it is appropriate to amend your order, so if you have an order,
I do not, Your Honor. I'll prepare one and submit.
I'll grant your motion and approve the order upon submitted. If you'll just hand that to the clerk.
Thank you, Your Honor.
Thank you.
I was recently retained by Ms. Washington on this, and I believe Ms. Toka is going to appear by Zoom, possibly. Ms.
She
Washington.
has been admitted, so we'll see if she can get her to, there she is. Good morning.
Good morning, Your Honor. Yes, I'm here, representing Mr. Washington.
Ms.
So
Toka, I emailed you a little while ago to say that I was retained to represent Ms. Washington. I hadn't had a chance to file a notice of appearance, but we're planning on going ahead and having the hearing this week.
All right, so are you
quite hear that
ready to proceed on this today?
Yes.
All right. Then, Ms. Tucker, you are going to be operating from remotely on this motion?
Yes, Your Honor.
All right, and Mr. Washington, is he here?
I believe he's on the Zoom remotely as well. I see his name there.
Let me see if I can. I'm going to ask there is Mr. Washington. All right. Then we are ready to proceed. This is, I believe it is Mrs. Washington's petition that's been filed in opposition to a relocation.
Yes, Your Honor.
All right. Then it's your petition, we'll let you put on your proof. So.
I'll call Ms. Washington.
Ms. Washington, I'm going to ask you to step around here to the witness stand.
I did.
State your name for the court.
Make sure that we pull that microphone down because we're obviously going to have to, with them
Sorry.
on Zoom, you're going to
Is that
have
better?
to speak directly into the microphone. So.
Can everybody hear me on the Zoom?
Yes.
Okay. All right. State your name for the court.
Noelle Washington.
Okay. And you were previously married to Jeffrey Washington, correct?
Yes.
And you guys entered a parenting plan, which we had done that was reportedly temporary. I believe the court's made a ruling on that. But at that time that was entered, there was an idea that Mr. Washington might relocate at some point due to his employment.
Yes.
Okay. And so I believe the judge has already ruled that the relocation statute doesn't apply, but we were supposed to be heard today about school enrollment, which you have objected to for a number of reasons. Can you state the reasons that you've objected to the move?
Yes, the kids are established here. They've been going to school here, their family's here, their pediatrician's here that they've been seeing since they were little. Their dentist is here. My daughter Nyla, she's in cheer at the middle school in White Bluff. And then my 9-year-old daughter Callie, I had it to where she could do summer school because she didn't do well on her TCAP, even though she made good grades. So instead of them doing summer school, they were going to let her, throughout the upcoming school year at White Bluff Elementary, do tutoring so that she wouldn't be held back.
Okay. And are there any other reasons that you don't want the children to have to go to school in Davidson County?
Just that I don't feel like it'd be beneficial for them, the kids,
Why?
because they don't want to go.
Objection, Your Honor. The children's preferences are not a factor in this matter, and that's hearsay.
Remember, we can't talk about what the children have said.
Yes, I
Okay.
apologize.
That's all right. And so you said that your which daughter, Callie, is in tutoring or needs tutoring? Is that
Yes,
correct?
throughout the upcoming school year.
Okay. Is she supposed to be doing that this summer at all?
There was an option for her to do summer school, but it would be hard with the week that she's with her father for him to get her to summer school during that week.
Okay. Well, do you know if they offer tutoring at the school that she might be going to?
I do not.
Do you know what school she might be going to?
I do not.
Okay. And your children are in different grades, correct?
Yes.
Your youngest one is not even in school yet, is that correct?
Yes.
And your oldest one is still in middle school?
She's in middle school. She's going into the 7th grade.
Okay. And they have friends here?
They do.
They have family here?
They do.
And do they have any family in Nashville besides Mr. Washington?
I believe his sister.
Okay. And so, given the situation of y'all's plan, where you have the children somewhere, you have to take them to school, and that might, is that going to be difficult for you?
It would be difficult to travel to get them there on time from West Dixon to Hermitage.
Okay. How long does that take to drive?
I'm not sure, depending on the exact location of the school that he would be trying to enroll them in.
Okay. Was there anything else going on that makes White Bluff better, as far as, in your opinion, of where they should go to school?
No, ma'am. Just
what we've talked about?
Yes, ma'am.
Okay. And you said your children make good grades?
They do.
And they participate in many activities, is that correct?
Yes, ma'am.
And so Nyla participates in cheer.
Yes,
Is there
ma'am.
football or anything for the other ones?
They were in football and cheer, but that hasn't started up yet for this year.
Okay. And do you know if they'll still be able to participate in those type of activities when they get there?
They will here. I'm sure they could there too, if that's what the kids wanted to do.
All right. I'll pass the witness.
All right, Ms. Tucker, you have questions for this witness?
Just a few, Your Honor. Can you hear me okay?
Yes, I apologize.
No, it's okay. Just making sure. Ms. Washington, you mentioned difficulty getting the children to school during your time. But isn't it true that during the school year, your ex-husband, Mr. Washington, he has the children primarily during the school year, correct?
On paper, yes.
Okay. And so in your parenting plan, he has them for every 2 weeks. Isn't it true that he is the one taking them to and from school almost, would you say, 3 or 4 days a week?
It depends. A lot of it was my grandfather that he was living with.
Okay, but I guess I'm asking about the plan. Isn't it true that he is to take school 3 or 4 days each week, correct?
Something like that.
And you take them significantly less to school during the school year, 1 day a week max, correct?
No, it is more than 1 day a week.
Okay. Isn't it true that it's you pick them up from school on Thursday, then you're responsible for Friday every other week?
Yes, and then the off week, I have them on a Wednesday, I believe.
On a Wednesday. Okay.
I don't have the plan in front of me.
Okay. Well, so significantly, like you said, on the off week, you have Wednesday, and then on the the week where you have more time, it's Thursday through Friday, correct?
Yes.
And you are employed, correct?
Yes.
Are you employed as a waitress?
Server.
Server. And your ex-husband, he is employed, as I believe you know, as a full-time property manager, correct?
Yes.
Okay. And so he is responsible for taking them. Well, and let me withdraw, sorry. According to your parenting plan, he has about 80 more days per year of parenting time responsibilities than you, correct?
On paper, yes.
Okay. And that is a court order paper, correct?
Yes.
So that's what should be followed. And would you agree that since he is primarily the one taking them to and from school, it is in your children's best interest to not have to commute multiple hours a day the majority of the time to go to school in White Bluff?
I'm sorry, I'm not understanding what you're asking me.
Okay. So if your ex-husband, Mr. Washington, is taking the kids to and from school, and he works in Nashville, in Hermitage, do you agree it would be in your children's best interests to have a shorter commute to and from school when they're with their father?
I'd agree that'd be for both of us.
Well, but you agree that Mr. Washington has your children during the school year in particular a significant majority of the time, correct?
That's a part of the parenting plan, but that's not what happens.
Are you saying you don't follow your court-ordered parenting plan?
I say that we discuss things and he's not there a lot of times. My grandfather's the one that usually takes the kids, picks them up, has them till he gets home around 7-something at night.
And that's because Mr. Washington is working in Hermitage, correct?
Yes.
Okay. Isn't it true that your ex-husband, Mr. Washington, is very much involved in your children's education, helping them do their homework?
For the most part, yes.
And he's very supportive of their extracurricular activities, correct?
For the most part, yes.
Isn't it true he even coached your son's football team at one point when he was in football?
He did.
And per your parenting plan, your ex-husband is responsible for those extracurriculars, the ones you mentioned, cheer, football, any other softball. He's responsible for paying 75% of all of the costs of those things, correct?
Yes.
Right. And so, okay. I think I have no further questions for this witness, Your Honor.
Correct, Ms. Coffenberry. Thank you, ma'am. You may step down and have a seat at the table by your lawyer. Ms. Coffenberry, you may call your next witness. Step right around here, please, ma'am. Raise your right hand. Let's place you under oath.
Yes. Say your name for the court, please.
Anita Nicholson.
And how are you connected to Ms. Washington?
I'm Noel's aunt.
Okay. And have you had an opportunity to observe these folks' involvement in the children's lives?
I have. I've been there ever since they've been born.
Okay. And so have you, since they have been separated and gone along, have you seen Noelle with her children?
I have.
And have you known her to have them with her and take them places?
Yes.
Okay. And have you observed her involvement with them and taking care of their school, education and things like that?
Yes, and picking them up when she has them and taking them on time.
Okay. And that seems to work well.
It does. The kids are happy there.
So, do you have
Your Honor,
concern?
objection to the kids happy, I'm not sure how she can testify about the children's.
She can testify about what her observations are of the children's behavior, and she cannot repeat what they say, but she can testify about their general demeanor and behavior, so overrule the objection.
Okay.
I've been in their life a long time,
Okay.
and I'm very active in it.
Okay. So since this move idea came up, have you observed any changes in the children?
Your Honor, objection. The children are under the age of 12. Their preferences in this matter are not relevant. And I think they're trying to backdoor what their preference is by her observations, but that's not statutorily a basis for a custody decision.
Well, this court has previously found that the address that Mr. Washington is relocated to is less than 50 miles.
Yes.
Therefore, the parental relocation statute is not triggered. So what we now have is basically Mrs. Washington's objection to the school being changed for the children. And frankly, that would require a petition to modify the parenting plan that was adopted by this court. And that parenting plan, which was an agreed parenting plan, not one ordered by the court, but an agreed parenting plan, was filed February the 13th of 2026, signed off on by both Mr. and Mrs. Washington. In that parenting plan, Mr. Washington is designated as the primary residential parent. And it apportions the days at 140 days per year with the mother and 225 days with the father. He goes on to set out that the mother will have the exercise her parenting plan every other week on Thursday afternoon, when she'll make arrangements to pick up the children from school until Monday morning, when the mother will return the children to school. The schedule is supposed to begin February the 11th, 2026. Then it goes on to talk about the off week. She gets Wednesday afternoon until Thursday morning when she takes the children back to school. So she sees them every week. More concerning to this court is the subsection J, other following special provisions apply. The very first one of those is that this parenting plan shall remain in place until July the 12th of 2026. The parties agree that the parenting plan may change depending on the location of where the minor children are enrolled in school for the 2026-2027 school year. Now, someone explain to me what that means?
Well, Judge, since I was part of, with Ms. Franklin, trying to create this plan with these folks, we sat down, and because we knew that Mr. Washington might move, and also in anticipation of them developing a better co-parenting relationship, that in July we would revisit it so that we could come up with an alternative schedule, was the plan.
Well, I know you were not involved in the initial filing of this proceeding, but the court is of the opinion that we don't really have anything filed before this court that would allow me to make a modification of the parenting plan. What it sounds like is that Mr. Washington may have envisioned that he was going to relocate, and you all agreed to this, but said that it will last until July the 12th of 2026, and thereafter, something else is going to have to happen.
Yes, sir.
But no petition has been filed to modify that parenting plan. There's only an opposition to the relocation.
Right.
That has not been triggered by the statute. Therefore, this court is of the opinion, I don't have anything before me today that would allow me one way or the other to rule in what you're requesting. I think you are free to, without prejudice, to file a petition to modify the parenting plan based on the very fact that it was envisioned that it would be modified. The question then becomes, is that going to do away with the requirement of a change of material, a change of circumstances, which is normally what is required to change a parenting plan? But based on my review, while this has been going on, of this parenting plan, in this particular case, I'm of the opinion that I must dismiss this action because it does not meet the criteria for a opposition to a parental relocation, and give you leave to file a petition to modify the parenting plan as envisioned in subsection J1 of your parenting plan that would address these issues. Ms. Toka, I'm of the opinion that this is the appropriate way to handle it. So,
And if that were to happen, Your Honor, and they would have leave, obviously, like you say, to modify, to file a petition to modify, if that's what they want to do, would there be any objection to Mr. Washington enrolling the children in his new school district, since he is
he's
the
the primary residential parent. Under the parenting plan they agreed upon, they have joint decision-making, but if they cannot agree, he makes all the educational final decisions. So enrolling the children in a different school is an educational decision. So I would suggest that if you're going to oppose that, Ms. Coffenberry, you need to get something filed to modify the petition, the parenting plan, get a petition filed and try to get a hearing as soon as possible. Because obviously it's within his purview under that agreed order that he be allowed to make these decisions. So,
All right.
all right.
Well, that's what we'll do, Your Honor. Thank you.
And so, Your Honor, I'll submit an order that reflects that.
Just make sure that it shows that this court's of the opinion that because the parenting plan, parental relocation was not triggered by the distance requirement, and there was this case cited by you in one of your filings that I have read, and it is correct. It is not the lineal miles, it is the direct miles that govern it. So if you'll put in there that the court doesn't find that this has been triggered by the relocation of Mr. Washington, and that it would be necessary for a petition to be filed to modify the parenting plan in order to give us what we need to do about ruling. So, all right.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
What looked like a routine school dispute turned into a courtroom shocker. A mother tried to block her ex from changing the kid's school after he moved, but the judge found one critical detail in their parenting plan that changed everything. Then came the bombshell: the entire case was dismissed. Did the judge get it right? Watch the full courtroom drama on the channel and let me know what you think. Like, comment, and subscribe The Legal Lens for more real court cases.
Good morning, Your Honor.
Good morning.
Donald Patton, Sergeant First Class, U.S. Army, retired. Your Honor, I'm appearing today as a pro se litigant. I have a non-attorney assistant, Rachel, who's been helping me organize and manage my
Your on-screen
documents.
assistant is, unless they are an attorney at law, they are not going to be allowed to participate in this hearing. The practice of law is limited to those people who have been licensed by the state of Tennessee to practice in the courts of the state of Tennessee. And an on-screen assistant is not someone who, unless they are shown to have an actual license to practice law, they will not be allowed to participate in this case.
Yes, Your Honor. My ask was to allow her to assist me with the documentations of getting it sorted so that we had it present and quickly for me, not to, as an assistant with regard to any kind of...
As stated before, if she is online, she's been admitted into this hearing room, but she is not going to be allowed to participate in the case.
Understood.
You have filed a petition for emergency ex parte temporary restraining order and a motion for an expedited hearing. And I think there was a hearing in front of Judge Larry Wallace, is that correct?
Yes, Your Honor.
And Judge Wallace denied your request for an emergency ex parte temporary restraining order and then set the matter for this court to hear. And that order was entered on June the 4th. And basically that order recites the following. The court reviewed all of the recent pleadings filed by the plaintiff on June 2nd. In addition, the court reviewed the detailed final decree of divorce, which was entered on August 21st of 2025. When reviewing the totality of the pleadings in this case, the court believes that there is insufficient proof at this time to grant an ex parte temporary restraining order. Moreover, the court noted that in the final decree of divorce that the plaintiff lacked credibility on many issues. Nevertheless, the court does set this matter for hearing on Monday, June 15, 2026 at 9 a.m. in the Dixon County Justice Center in Dixon County Chancery Courtroom 5. So basically, Judge Wallace has deferred it to me to hear. So we are here today on your request for an ex parte, and I noticed that you this morning have filed a motion for Rule 60 relief from the judgment in this case. Would simply observe that under the rules of civil procedure, to hear a motion, you must give 5 days advance notice to the opposing party. So Ms. Duke, are you opposed to hearing on the Rule 60 relief without proper notice? Rule has been requested, so anyone who is going to be a witness in this case must go outside of the courtroom and remain outside of the courtroom until you are called to testify.
May I grab my documentation,
You may.
Your Honor?
We will not be hearing your Rule 60 motion because the not proper notice has not been given under the rules. So you're limited to your ex parte or your motion for a restraining order.
Understood, Your Honor. I have a opening statement prepared. All right, Your Honor, this morning I filed a Rule 60-102 derived for motion for relief from final judgment, setting forth 10 specific grounds for relief, derived specific part this court's own audio record. A motion for evidentiary hearing, requesting a full hearing on those grounds no later than August 3rd, 2026, within.
What are you referring to when you make this statement?
I'm just trying to let the court know that I filed this morning, Your Honor.
Well, what you filed this morning is not before the court because you've not given proper notice. We are not considering a Rule 60 motion, so I sustain
Understood.
the objection.
Okay.
You have asked for a restraining order, and that's the only issue that's before me today.
Okay. Understood, Your Honor. Your Honor, circumstances have developed since the entry of the final decree that have rendered the current property arrangement financially untenable for both parties and impossible to perform as written. The homeowner's insurance on the marital residence at 2358 Petty Road, Charlotte, Tennessee has been canceled effective June 3rd. Neither party is legally able to reinstate that insurance policy at this time. I do not occupy the property, which is required by the policy, or insurance policies in general, and the respondent is not a mortgage holder of the home itself. PennyMac has confirmed that they will place.
You cannot repeat what a bank or an insurance company or anyone who's not a witness from the witness stand has said. That would be hearsay. So I sustain the objection. Ms. Duke, turn on that microphone there, please.
Sorry, I didn't realize it wasn't on.
You need to confer with your client. You can turn it off, but if you don't mind leaving it on, that way you don't have to turn it on and off all the time.
Yes, sir, thanks.
Your Honor, so there is a forced policy that will be put in place by PennyMac.
Well, let me ask you this question. You've read the final decree of divorce.
Yes, Your Honor.
And you're aware that under the final decree of divorce, that she was granted the ownership of that house, correct?
Yes, Your Honor.
And that your claims against the equity in that house were offset by the $50,000 or so that I found that had been invested or that had been wrongfully taken out of marital funds in the final decree. That was the reason why she got the entirety of the equity in the home. and that you were to be divested of that interest. And so she's the owner of that property under that final decree, which was entered August 21st of 2025. So what exactly are you saying she should be restrained from doing?
Your Honor, the original TRO the request was to put me on the property as an occupant so that I could reinstate the insurance policy, because the insurance policy was dropped due to not being an occupant of the home. So that was the sole purpose of that emergency TRO, was to try to reinstate the insurance policy so that my family was covered, and all of their belongings and everything was covered within their insurance. So,
Respectfully, we had to file the final decree of divorce. I've sent him an email about that, had it at the office. He's come by the office several times and we've never signed the quitclaim deed. My client is able to get the home. She's had to go to the Register of Deeds office and register the final decree, as opposed to the quitclaim deed required to sign under court order.
Your Honor, signing over my rights to a property that I am solely liable for puts me completely upside down, and it's completely inequitable.
Why wouldn't you sign a quitclaim deed?
Why wouldn't I sign it?
Yes, sir.
Because that removes all rights that I have of any access to that property when I still maintain the mortgage solely in my name. It's a VA mortgage.
Well, she can't, you understand, she can't get a change in the mortgage unless she owns the property outright. The order that was, the final decree rather, provides that the marital residence located at 2358 Petty Road, Charlotte, Tennessee, 307036 is awarded to the wife. Any and all marital interest the husband has to the real property is hereby divested from him and vested in the wife. And Ms. Duke, do I understand you have recorded that final decree?
We've recorded the final decree, but we also brought a quitclaim deed here today for him to sign if the court was inclined to instruct him to sign it.
So the final decree and the order that this court put down over a year ago is awarding her that property and divesting you of any interest. So you no longer own an interest in that house.
Yes, I'm aware, Your Honor.
To order to get the mortgage changed out of your name and to put it into her name solely, she has to have whatever the documentation is that's necessary. A quitclaim deed is a deed that says whatever interest I have in the property, I'm conveying to the other person. And you're not making any warranties, you're not doing anything other than saying, I don't have any other interest in the property. So with that being the case, it would make sense that it is in your best interest to sign the quitclaim deed to the property so that she can then get the mortgage into her name individually. Is that what she intends to try to do, Mr. Duke?
Yes, Your Honor. That's what she's been working towards for the last year. And I would submit to Your Honor, this all revolves around a $31,000 insurance check she received for damage to the property after the property was awarded to her. She turned it into insurance, she did everything she was supposed to. And he's making some claim to an insurance proceeds check for damages to the real property that she owns. So that's where this kind of came to a head, and we just need him to sign this and to sign the insurance check.
All right. I've interrupted you, but I want to give you an opportunity to, again, explain to me what it is you're seeking to do in this temporary restraining order that you sought, which is all I'm hearing today.
Yes, Your Honor. Once again, so the only purpose for the temporary restraining order was to get me put in a situation where I had occupancy to reinstate the insurance policy, because the insurance policy was dropped due to occupancy. So I was trying to reinstate that. That window has passed and closed. The insurance is now closed and gone. That policy's been shut down. The property currently is valued roughly around $300,000 as per the CMA that I just received, and it's now sitting completely uninsured at the moment, Your Honor. It's not good for both the mortgage. It's not good for my VA entitlement. It's not good for our children. To have this house completely unsecured and just floating in the wind.
As we understand it, and I think that if records were subpoenaed, I think the records would reflect that he actually called and canceled the homeowner's insurance policy. which obviously is in bad faith, and it's actually, you know, similar to the things that he did during the divorce. It's all to get at Ms. Patton because she was awarded.
All right, well, I've allowed you to make an opening statement, but it was unsworn statement, so if you want to put on your proof, I'm going to let you be placed under oath and take the stand, and we'll let you testify about what it is you're asking me to do. Do you wish to put on proof on this issue?
No, I don't believe so, Your Honor. I mean, I think if that's kind of where we're at, like I said, the TRO it's kind of come and gone at this
All
point.
right, since you have declined to put on any proof, that is this court's order that you sign that quitclaim deed, and that thereafter, Mrs. Patton will be required to obtain insurance on the property in her name only. She will be required to seek and obtain replacement mortgage coverage for the home to release Mr. Patton from all liability on that. Is any idea of time-wise how that, if he signs it today, any indication as to how long that will take?
There isn't, Judge, because we've not been able to get to that point due to the quitclaim deed. If we need to set it for a review some 60 days out, I think we could do that.
All right, set it, what's 60, give me a date, 60 days out. I want to get you released from the liability on the mortgage and give you what you need. And that way, I understand you, if there's no insurance on it, then there's a risk to, both of you for that. So we're trying to fix your problems as quickly and expeditiously as possible. So with me ordering you to sign the quitclaim deed, it still preserves your right to argue that Rule 60 motion if you want to. But I'm going to try to fix these things as quickly as possible to let her obtain the insurance immediately, and to then take the steps to try to release you from the mortgage.
Okay.
And we'll do those, we'll set a review 60 days down the road to make sure she's done those things.
Sounds good, Your Honor.
Right. That'll be August 26th.
Yes, Your Honor, I'm available that day.
All right. That'll be in front of a different judge, but the order will reflect what I've done, and that should take care of it.
And that 60 days is not, that's just a review to make sure.
It's a review to see if what progress she's made in complying with the court's order that she obtain insurance in the property in her name only, and that she takes steps to try to get the financing to release Mr. Patton.
And
Okay.
may I request that he be required to sign that check if I put it at the front desk at my office?
Once I awarded that property to her, the check is hers from the insurance company. So yes, I'll order that Mr. Patton needs to sign that check over to her as well. All right, then Ms. Duke's going to draw an order and submit it to you so that you'll see what the order says and make sure it is correct. And then I will sign it after that. All right, thank you.
The only other issue was fees being awarded in this matter.
No, that will be reserved.
Thank you, Judge. I'll make sure I put that in the order.
All right. Then that concludes our business for today. You two lawyers, huh? Oh, no. Wait a minute. I thought that was it.
Right here? Yeah, 15.
I see it, okay. The motion for a mandatory injunction in Williams versus GCD Enterprise.
Yes, Your Honor, and this should be pretty easy. We filed that motion, we sent, I thought we sent a copy to Mr. Mills, I don't believe it was sent.
I didn't see any service in the file this morning. I think there's no return of service of process. And then, so I can't do anything until there is a service on the defendant, but.
I spoke with Mr. Mills on Friday, and what I told him I was gonna come do is ask the court if there are any other days in June that the court could accommodate.
Any other day in June?
Accommodate a hearing on this case, yes, sir.
Well, this is not even I'm supposed to be in Waverly, Tennessee today. And the only reason I'm holding these days court is because trial got continued. I don't have any other chancery days in June here in Dixon County, but do you have another day in June? I mean, tomorrow is the only other chancery day until after July. Do July 1st? What do you want to do?
Yeah, I guess we'll check to see if anybody else, of course, is, that's the reason.
Check with Judge Turnbow. He's in his office today. He might
That was
be
the
able to
reason
give
for the
you.
injunction was, we were needing relief as quickly as possible, so.
I understand from what your pleadings state that there's an urgency to it, and I'm sorry I don't have any open days to give you after tomorrow. I will say that if you will check with Judge Turnbow, he might be able to, if he's had some openings, he might be able to work you in, so.
Yes, Your Honor.
Don't mean to speak for him.
Thank you, Your Honor.
All right. Mr. Spratt, why are you here? She told me that y'all had reached an agreement. Is this kind of like the Iran and situation where there is or is not an agreement? No, there is an agreement. No, there's not an agreement.
We've agreed to set it once we do the definitions and he may want to go ahead and obtain it. Just give us enough cushion time to finish up depositions and maybe.
I'm gonna pass that.
So you want to pass your motion to compel?
Yeah, I'll probably strike it.
All right. Then are you asking what kind of case is this? All right. And you want to get a date in front of Judge Lockhart Mash or Judge Wallace or Judge?
Your Honor heard a lot of this.
You assume I would be interested in hearing the rest of it. So.
You were right, and you know what it's.
So this is Williams versus Williams, okay. All right. Wait a minute. You said you don't like to put long hearings on my days? All right. What days? We have September the 1st at 10:30, September the 2nd, September the 3rd, September the 4th. What have I done? And I've given out the 21st and 22nd to you as well. That's 1, 2, 3, 4, 6 chancery days that I gave you for the month. September 21st or 22nd, those are chancery days as well.
21st works for my calendar. The only thing I'm told.
This opposing counsel standing next to you. She's playing soccer for which high school? Oh, college. Yeah, she is that old? You're a lot older than I thought, so. I can say that because I just had a birthday, so. What college is she playing for? We'll give her a little free advertisement, so. All right. Are you going to find out whether or not that's going to
We
conflict?
should be finding out the schedule in the next few weeks. On right now, but we can put it on this date, and I'll move to continue it or call your office to get an alternate date.
That's fine.
Probably about 3 hours, half a day. Once we get started, the court's going to remember a whole. We're not going to have to backtrack on some things.
Oh, wait. You haven't been to mediation? Y'all read the local rules anytime?
I find that.
There's no one.
It's kind of like killer bees. We don't need no stinking rules. Is that it? So, all right. I will waive. Look, I have confidence in the two of you. If you think that mediation would be successful, I'll order mediation. If you tell me that there's no likelihood you're going to reach an agreement and that would be a waste of time and money for your clients, then I will waive the mediation.
It will absolutely be a waste of time.
All right, waive mediation and allow them to set the final hearing on that date in September. It obviously is now stuck with me because the other judges might not waive the mediation, so.
Is it 9?
It's 9 a.m.
9 a.m.?
7:30
For
a.m.
me.
I
That's
could be
probably
here.
what you need to do to
We
get
put
your
it for
time.
you at 7:30. You might show up at 10. I don't know. So.
I'll go knock on the door and get them out of
Mr. Spratt has a history of showing up a little bit late. I'm telling you, one of these days I'm going to do to you what Judge Martin did to me, and that is I went across the street at the old courthouse to the historic courthouse for general sessions, and Jennifer Roberts called me when I was practicing law and said, "Do you represent Joe Blow?" And I said, "Yeah." She said, "Well, you might want to get over here. Judge Martin just started your case." I walked in, my client was sitting there with a deer in the headlights look on his face, and the wife was on the stand being questioned by her lawyer, and Judge Martin said, "Mr. Wolfe, do you represent this defendant, this husband?" I said, "Yes, sir." He said, court starts at 9 o'clock. It was like 5 after, and I said, "Yes, sir." Anyway, I told him.
The record reflect, I'm not opposed to that judge.
Anyway, it taught me to never be late in front of that judge, so.
I'm a work in progress on that.
Anything else? Hassel, you have anything? All right, going once, twice. We are done. Thank you for your attention.
A retired Army sergeant walked into court hoping to stop his ex-wife from taking full control of their former marital home, but the hearing quickly took a dramatic turn. The judge reviewed the divorce order and made it clear that the property had already been awarded to the ex-wife, leaving little room for debate. As tensions rose, the veteran argued that the home was uninsured and that he was still tied to the mortgage, while the court focused on resolving the ongoing dispute. In a major ruling, the judge ordered him to sign over the deed, endorse a $31,000 insurance check to his ex-wife, and cooperate with the process of removing his name from the mortgage. The judge also scheduled a future review to ensure everything moves forward. Was this a fair decision based on the divorce decree, or was the veteran put in an impossible situation? Watch the full courtroom drama and let us know your thoughts in the comments. Don't forget to like, subscribe, The Legal Lens and turn on notifications for more real-life legal battles and shocking court moments.